Federal judges face the same strict set of ethics rules, except the judges at the very top. What will it take to rein in the U.S. Supreme Court? Hey there, I'm Joshua Johnson, and the Nightlight is on. Tonight on the show, answering your questions about the Supreme Court. Some of the justices have been under more scrutiny after news reports about conflicts of interest. That's just one thing you've been asking about. We'll put your questions to a legal expert about the current controversies and the court's future. Michigan State's law school dean, Linda Sheryl Greene, is with us. She'll help us break down what's behind some of the major rulings from recent months. And we'll dig into some of what you told me you're feeling about the Supreme Court today, including despair. I always love to hear from you. Follow me on social media at Joshua Listening, email joshua@nightlightshow.com, or reach out on my website, nightlightshow.com. Joining us now is Linda Sheryl Greene. She is the Dean and MSU Foundation Professor at the Michigan State University College of Law. She's a civil rights attorney who has served as a counsel to the U.S. Senate Judiciary Committee. She's been a professor at the University of Wisconsin, Harvard, and Georgetown, and has worked for the NAACP Legal Defense and Educational Fund. Dean Greene, welcome to the program. Good to have you.
It is such a pleasure to be here with you.
Let's start with one of the cases you referenced involving the same-sex wedding in Colorado. Let's start with one of the cases that you referenced. Following on that case with the baker in Colorado, this was the case of 303 Creative LLC versus Elenis, and it was a First Amendment question regarding being able to express views that are contrary to someone's religious beliefs. There was a woman in the Denver area who owned a web design business, and she sued preemptively out of concern that Colorado's anti-discrimination laws would force her to provide services for a same-sex wedding ceremony. Let me read an excerpt from the opinion in this case, which was written by Justice Neil Gorsuch. He wrote in part, quote, "In this case, Colorado seeks to force an individual to speak in ways that align with its views, but defy her conscience about a matter of major significance. In the past, other states have similarly tested the First Amendment's boundaries by seeking to compel speech they thought vital at the time. But as this court has long held, the opportunity to think for ourselves and to express those thoughts freely is among our most cherished liberties and part of what keeps our republic strong." He goes on to write, quote, "Of course, abiding the Constitution's commitment to the freedom of speech means all of us will encounter ideas we consider unattractive, misguided, or even hurtful. But tolerance, not coercion, is our nation's answer. The First Amendment envisions the United States as a rich and complex place where all persons are free to think and speak as they wish, not as the government demands," unquote. That's part of the opinion that was written by Justice Neil Gorsuch, and this was a 6-3 ruling. Dean Greene, how do you see the Supreme Court's balancing of religious freedoms with anti-discrimination? That has come up in a number of cases in the last few years, particularly as it relates to same-sex marriage.
We know that we have numerous laws, state laws, local laws, and federal laws that protect various groups of people from discrimination on the basis of their gender, on the basis of race, national origin, sexual orientation, etc. And so what's really important about this case is whether it's possible to draw a line between the argument that baking a cake is speech and the argument that someone who engaged in the provision of public services should serve all people without discrimination. It may be that it is possible to limit this case to those circumstances in which the message in which the service desired actually requires that an individual state a message, but I think there's an argument that if in fact speech includes expressive conduct, that we have the possibility that people will now argue that if a person who is providing public services is compelled to serve people in the public without discrimination, that refusal may be treated as expressive conduct and therefore jeopardize the many laws that we have to protect public accommodations. And those laws, of course, came to us as a result of hard-fought battles for civil rights.
I think part of what you're getting at, Dean, is expressed in the dissent. Here's part of it that was written by Justice Sonia Sotomayor. Quote, "The unattractive lesson of the majority opinion is this: what's mine is mine, and what's yours is yours. The lesson of the history of public accommodations laws is altogether different. It is that in a free and democratic society, there can be no social castes. And for that to be true, it must be true in the public market. For the promise of freedom is an empty one if the government is powerless to assure that a dollar in the hands of one person will purchase the same thing as the dollar in the hands of another. Because the court today retreats from that promise, I dissent." Unquote.
Justice Sotomayor is expressing the concern that I have that if we treat the refusal to provide service to people as a form of speech without regard to the consequences or without regard to the circumstances, that we are beginning to open the door to a significant limitation of our public accommodations laws. And of course, those who oppose those laws express their view to express a different opinion, but we treated those expressions as conduct inconsistent with our fundamental public policy.
Now, I wonder how this works both ways, or if this works both ways, because what I've heard a lot of in response is, okay, you don't want to serve same-sex couples, that's fine. How about if gay florists and gay DJs and gay wedding dress designers are like, I don't want to serve evangelical Christians, because y'all people have been coming down on the community forever and ever, and turnabout is fair play, and let's see how you like it. That would prompt a gigantic uproar. But I've heard a number of people say, and some of the folks who follow me online have expressed, you know what? If the law is supposed to apply to everybody equally, then it's time that evangelical Christians, anti-gay Christians got a taste of their own medicine. But I don't know how the court would view that if it got to that point.
Well, I mean, you're saying the argument is we all have, under this opinion, for example, we all have the opportunity to refuse services to people with whom we disagree. I mean, is that the point?
Theoretically, yeah.
That?
Can a gay person do that to a Christian in response?
And is that enough to solve the problem of our hard-fought struggle to ensure that people are free from discrimination when they are involved in activities in public? It's an equal discrimination argument. It's actually very interesting argument. It was also argued in the context of interracial marriage cases that blacks could refuse to marry whites, and whites can refuse to marry blacks, and thus these laws are equally applicable and therefore constitutionally tolerable. But we haven't taken that position, but we can see where we go with that the equal opportunity to discriminate does not resolve the question whether the discrimination itself is against our fundamental, not only public policies, but against our fundamental constitutional policies.
Let me zoom out a bit and ask two related questions that came from listeners about this case. Liz emailed, is religious freedom more important than individual freedom in America? And Daisy tweeted, "How can it be legal for conservative Christian politicians to pass laws imposing their religious doctrine on all of us? I'm talking abortion bans and anti-LGBTQ laws. Does religious freedom trump individual freedom in America?" Dean, I think that the court, particularly the Chief Justice, might argue that the goal is to balance those two sets of freedoms, that they're all kind of wrapped up in the same parts of the law, but depending on who you are, it doesn't always feel that way.
Well, I love these questions from Liz and Daisy. Both types of freedom are extremely important, and in my view, they're fundamental to our basic constitutional system. But we should observe that for many, religious freedom is included in any notion of individual freedom. Therefore, I'm not sure that we can separate those two. Individual freedom may include the right of an individual to embrace no religious tenets whatsoever. So, on the other hand, the exercise of an individual or a group's religious freedom may curtail the individual freedom of others. So, they are very much related, and they're not, one is not more important, but we do have a First Amendment that provides protection for religious freedom as well as the right of speech. Maybe, if you don't mind, I'll read it and then maybe come to Daisy's tweet. So the First Amendment says, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech." And so to Daisy's question, the Supreme Court, under its free exercise and freedom of speech, has protected the right of all people and organizations in the United States to participate in the political process and to contend for their ideas in that process. And there have been a number of cases in which the Supreme Court has affirmed the right of religious organizations to participate in that process, to argue for their ideas, and to have those ideas incorporated into policy. And some of those cases have arisen in the context of abortion. But there is a limitation on this principle, and that limitation is also contained in that same First Amendment, that the First Amendment does not permit legislatures to violate the free exercise of religion, and that government may not make a law respecting the establishment of religion. The right of religious organizations to participate in the public process of policymaking is protected under the First Amendment of our Constitution, the freedom of speech portion of our Constitution, but also that there are limitations on that, limitations that are also incorporated in the First Amendment.
Yeah, the spirit of the First Amendment is kind of that religious activity is supposed to be neither advantaged nor disadvantaged. It's allowed, but the government isn't supposed to put its thumb on the scale on either side. One more thing about this case, though, before we move on to another one. There's been a lot of controversy over how this case came about, and an email that was supposedly sent to 303 Creative by someone named Stewart, who said they had a partner named Mike and they were getting married and could you make us a website. The New Republic reached out to Stewart because Stewart's information was in the court records and said, "Hey, what do you think of this?" Stewart, as it turns out, says that he is a web designer, so why he would need web design help, who knows, and is based in San Francisco, not Colorado. And Stewart told the Washington Post that he is already married to a woman and has been for 15 years. Does it make a difference if a pre-enforcement challenge like this, a lawsuit saying I could be discriminated against, I have a case, does it make a difference if that is brought forth on false pretenses? The attorneys who represented Lori Smith, who owns 303 Creative, have balked at the idea that they would knowingly lie to the court to set a new precedent. But does that make a difference in the eyes of the law?
Well, whether there is truly what we call a case or controversy, or whether someone has actually been injured or affected by a law, is a very important issue in all cases. The circumstances in which the federal judiciary may consider cases are limited by Article 3 of the Constitution that governs the power of the federal judiciary, and that power is limited to actual cases and controversies, which means that there must actually be a dispute that requires the resolution of this case by the Supreme Court. So you're actually mentioning maybe two things. Did Lori falsify the circumstances under which she felt a threat to her right of speech? If that is true, that information or that issue, to the best of my knowledge, was not presented to the courts. So you're wondering, well, is this really a controversy? I think that might be different from asking the question whether the circumstances under which the court decided this case were legitimate on the basis of everything that was presented at the time.
A fascinating case, an absolutely fascinating case, and we got a lot of response on that one. Let's get to a few other cases as we continue our conversation about the Supreme Court with Linda Sheryl Greene, the Dean of Michigan State's College of Law. I would love to hear from you about this or any other legal topic that's got you curious. Perhaps one of these rulings affects you directly. Tell me your story. You can email me, joshua@nightlightshow.com. Be sure to include where you live and how to pronounce your name. That's joshua@nightlightshow.com. Before this case came out, we were talking about an array of things related to higher education, including student loans. I'm going to get to affirmative action in just a second, but there was that ruling, Biden versus Nebraska, that had to do with the Biden administration's plans to forgive tens of thousands of dollars of student loan debt for students across the country, federal student loan debt. The state of Missouri was challenging that because it has its own nonprofit program, and it claimed that the Biden administration's program would harm its ability to ease the student loan burden of students in the state of Missouri. This was a 6-3 ruling that pitted the federal student loan program against the state student loan program. Here is part of the opinion, which was written by Chief Justice John Roberts. It reads in part, quote, "It has become a disturbing feature of some recent opinions to criticize the decisions with which they disagree as going beyond the proper role of the judiciary. We have employed the traditional tools of judicial decision-making. In doing so, reasonable minds may disagree with our analysis. In fact, at least 3 do. We do not mistake this plainly heartfelt disagreement for disparagement. It is important that the public not be misled either. Any such misperception would be harmful to this institution and our country," unquote. Dean Greene, he has been kind of like elbowing some of the more progressive justices on the court for a few years now. He gets a little prickly when it comes to the way that some dissents are written. Oh. Why is that?
Well, there's a big debate about the tone of opinions, about the failure of justices to make a distinction between their argument against the persuasiveness of an opinion with which they disagree and arguments that seem to border on ad hominem. So I think maybe about this particular case, what's important is it is a part of an ongoing controversy about the power of administrative agencies. So for me, I think that is one of the most important things about this case, and perhaps the way in which it might tie in to a discussion of the Clean Water Act case that you're going to talk about. The justices do differ on the extent to which they limit their remarks about another judge's opinion to the content of the analysis versus other opinions or statements that seem to be hyperbole. For example, the Secretary's plan has modified the cited provisions only in the same sense that the French Revolution modified the status of the French nobility and supplanted them with a new regime entirely.
That's from the Chief Justice's opinion.
That's from the Chief Justice's opinion. But that is, the argument could also be stated this way, that the Secretary of the Department of Education did not have the authority under the existing statutes to cancel student debt, and what goes along with that argument is that that's not the Secretary's right under congressional legislation, that Congress may specifically authorize that. And so I don't personally think that it's very helpful to use the terms of disparagement, and I'm not sure that the discussion of the French Revolution actually helps the people of the United States to actually understand what is at stake.
Yeah, everyone's got a little bit of an attitude on both sides. Just a little bit of attitude on both sides of this.
But I think that as you continue to explore Supreme Court cases, you and your listeners will see that, of course, they involve a very specific legal decision. The court agreed to review a particular legal question, and it decided it. But they also involve discussions about the proper role of the judiciary. They involve discussions about the proper role of agencies in the administration of federal laws. They also involve the question whether the court should require the Congress to pass laws with such specificity that it may be very difficult to get the kind of specific agreement that some members of the court think is appropriate when Congress legislates. So there are all these questions lurking below the surface. So when you ask, well, the disparagement issue, I think, is a question of tone. I think we can live with that. But the bigger and more important issues involve how much specificity we think we want to impose on Congress, 535 people, very, very difficult to get agreement when they are able to do so. Should we honor the result of that democratic process by allowing Congress to provide that authority to the agencies to make decisions under those laws?
Let me just close the loop on the dissent piece before we keep going. Justice Elena Kagan wrote in her dissent, quote, with regard to the disparagement, quote, "From the first page to the last, today's opinion departs from the demands of judicial restraint. I do not at all disparage those who disagree. The majority is right to make that point, as well as to say that reasonable minds are found on both sides of this case. And there is surely nothing personal in the dispute here. But justices throughout history have raised the alarm when the court has overreached, when it has exceeded its proper limited role in our nation's governance. It would have been disturbing and indeed damaging if they had not. The same is true in our own day," unquote. That's from Justice Elena Kagan. I think the larger question, though, Dean, that you're focusing on is the right one. What is the proper role of an administrative agency, the Department of Education, the Small Business Administration, the General Services Administration, any of the number of offices and bureaus that make the federal government work to do the thing that Congress designed them to do, right? They create an agency, the Corporation for Public Broadcasting, and they say, here's what you're allowed to do, here's what you can spend money on, here's what the limits are, here's what we expect you to do, here's how we want our money spent, go. And then these agencies go do their thing. I think to a lot of people across the country, they could care less. They just feel this is unfair. It's government's job to help people. The Biden administration tried to ease our student loan burden. We are drowning under student loans. And now the Supreme Court has said, go on and drown in. Good luck. I think to the everyday person, it feels like this lovely, wonky, intellectual, legal argument that at the end of the day is still going to cost everyday people $20,000 that they don't have. How do we grapple with that?
Well, if we look at this question from the perspective of the proper role of the judiciary in the administration of law, we have not heard the term very frequently associated with majorities we might characterize as conservative, that they are acting in a manner that is activist as compared to exercising judicial restraint. And Justice Kagan talks about the departure from the demands of judicial restraint. But another way of looking at a case like this is from the point of view of whether we think that the appropriate role of the court is to exercise restraint when Congress has acted and an agency has acted pursuant to that authorization. There's another approach that the majority could take, is to say, we disagree with what the Department of Education did, but we will leave it to Congress to decide whether to repudiate that, given the millions of people who are involved and affected by this decision that we make. So we talk about the question of activism versus judicial restraint. We often hear the term activism associated with justices who support individual rights or support opportunity for individuals. And here we see that there's an argument about activism, but not in the abstract, but asking the question, how should government work? And what is the role of the Supreme Court in policing the activities of administrative agencies?
Our guest is the Dean of the Michigan State University College of Law. Professor Linda Sheryl Greene is with us to break down some of the court's most contentious cases this term. I definitely want to talk in a moment about race-based admissions, also some of the other consequential cases this term, which, believe it or not, came down to a 9-0 ruling. No, not everything that the Supreme Court does comes down 6-3 or 5-4. Lots of rulings come down 9-0. We'll get into 2 of those rulings in just a moment, and we will talk about some of more of your questions regarding the integrity and the trustworthiness of the Supreme Court itself. We'll keep going with all of this just ahead. Stay close. This weekend, I'm going to the movies, and I would like your comments on 2 of this summer's biggest blockbusters for an upcoming episode. All right, hang on. I've always wanted to do this. In a world of atomic bombs and bombshell blondes, one podcast takes you inside the raw power of the first atomic weapon and into the empty head of the doll who's got it all. But this time, the star of our show is you. The Nightlight wants your reviews of the historical thriller Oppenheimer. Cillian Murphy stars as Robert Oppenheimer, the man who unleashed the atom into a new era. In the war for the soul of America, whose side are you on? Send in your reviews of Oppenheimer. How many stars out of 5 and why? Or share your questions about Robert Oppenheimer and his legacy. Email joshua@nightlightshow.com. And then, the luckiest girl in a perfect pink world leaves her dream house behind for a one-way trip to the real world. Margot Robbie is Barbie. Barbie. She's the adorable gal with an impossible figure sent on a quest to understand the purpose of life. Can she find what she's looking for? Does Ken really have her back? It's the existential crisis of the summer, and you're invited. Send in your reviews of Barbie. How many stars out of 5 and why? Or share your questions about this American pop icon. Be sure to write your email in pink letters. Just kidding, we can't read it that way. Email joshua@nightlightshow.com with your questions and reviews about Barbie or Oppenheimer. Or send your reviews of both movies, if you dare. Your comments on The Nightlight, coming soon to a podcast app near you. Oppenheimer rated R, Barbie rated PG-13, starts Friday in theaters everywhere. Support the show as a paid subscriber at nightlightshow.com. This is The Nightlight. I'm Joshua Johnson. We are answering your questions about the Supreme Court with Linda Sheryl Greene. She is the Dean of the Michigan State University College of Law. We're always glad to take your questions and stories about the Supreme Court or about any big issue that's affecting you. So email me, joshua@nightlightshow.com. You can also find me on social media. I am at Joshua Listening. Now, some of these cases have to do with going back to previous rulings, previous standards that were set up, not necessarily hard, kind of black and white, bright line standards, but asking, okay, well, how does this apply now? Things have changed. Maybe the circumstances are a little different. How does this apply now? Sackett versus EPA. That was a case involving a couple that bought land on a lake in Idaho, right near the line between Idaho, Washington State, and Canada, kind of in that upper corner of Idaho. And they wanted to build on it. And so they had been going back and forth over whether or not the waters were covered by the Clean Water Act. There were wetlands nearby, and there was a previous standard from a ruling that I believe was written by Justice Kennedy that had to do with a significant nexus of waters that were affected by the Clean Water Act. That significant nexus standard did not survive this ruling, though. And this kind of gets, Dean, I think, back to what you were saying earlier in terms of the roles of regulatory agencies, in this case, the EPA, what they can do, how we decide what the standards are, and then you've got everyday people in the middle like, but it's all water. It's all in the United States. Like, doesn't the EPA control all the water in the, like every drop of water in the lower 48? Isn't that all the EPA? And clearly it's more complicated than that, especially when you get into what agencies are allowed to do based on the way the law was written and what Congress intended.
At the beginning of the question, you suggested that they rejected a prior standard, but the problem, let's say, with the prior case on the scope of the Clean Water Act's application to wetlands is that prior case did not produce a majority standard. It actually produced 2 points of view about how and whether wetlands are subject to Clean Water Act regulation, a point of view from Justice Scalia and a point of view from Justice Kennedy. And so this was an open question that all agree had occupied the courts, the lower courts, since 2006, and so the Supreme Court takes it up. So you do get a 9-0 opinion here. You do get a 9-0 opinion, but what I think is really important about the opinion is it is interpreting a federal statute. So now we're talking about we're talking about not constitutional principles from the Constitution, but we're asking how should the court interpret a statute and how should the courts respect or not respect an interpretation of a statute that an administrative agency promulgated. So we're back in this area where we're asking questions. The Congress delegates to the Environmental Protection Agency the authority to promulgate regulations to enforce the Clean Water Act. The Environmental Protection Agency has made its decision about what ought to be covered, whether wetlands or which wetlands ought to be covered under the Clean Water Act, and the Supreme Court reverses that. And what we have here are What I like about this case, I'm not a scientist, but my understanding is that a part of the regulation doesn't really track the science in terms of the relationship between wetlands and other bodies of water. And there's an argument that there is not necessarily as clear a standard that the Supreme Court has provided. So the court says there's an Alito opinion that any wetland does not connect at its surface to another body of federally protected water, doesn't merit the same degree of protection as other waters of the United States. So you have all 9 justices agreeing that we need a new standard, but they split 5-4 on their rationale, and as usual, they poke holes in each other's judgment, and that we also see that the justices who disagree with the majority opinion also form an interesting coalition. We have Justice Kavanaugh, for example, writing, and he's joined in his judgment by Justice Kagan, Justice Sotomayor, and Justice Jackson. And they join only the result of the opinion and not the rationale. Kavanaugh saying that the court adopted a standard that would leave long regulated wetlands no longer covered, with significant repercussions for water quality and flood control throughout the United States. The other justices who...
I'm sorry, hold on one second. Hold on. Are you saying that Justice Brett Kavanaugh agreed with the 3 progressive justices on something?
Absolutely.
That happened?
Yes, it happened. They agreed that there should be a change in the prior standard, but not in the rationale. Justice Thomas and Justice Gorsuch joined the majority opinion, but they joined because they wanted to talk about limitations on the government's authority to regulate water. They wanted to talk about limiting these statutes so that they did not displace what Justice Thomas characterized as the state's traditional sovereignty over waters. And he also wrote this opinion to restate his long-standing concern with decisions under the Commerce Clause that don't draw a bright line between what is interstate commerce on the one hand and what constitutes manufacturing and production on the other. I just want to drop a footnote here that Justice Thomas is asking for a review. This is not the first time, a review of over 90 years of decisions on the basis of the Commerce Clause, and would like to go back to Depression-era understandings of the Commerce Clause. And that would have broad implications for the entire regulatory framework.
Let me move on to the case that I think has a lot of people talking other than the case out of Colorado that we mentioned. And that's the case that has to do also with universities, in this case with race-based admissions. There were 2 cases, actually. One was Students for Fair Admissions Incorporated versus the President and Fellows of Harvard College, and Students for Fair Admissions Incorporated versus the University of North Carolina. In both cases, these organizations argued that the race-conscious admissions programs violate the Equal Protection Clause of the 14th Amendment. Now, I should be clear, for those of you who are listening who may or may not have read the opinion or followed the details, we're not talking about affirmative action per se, the way that we knew it years ago. We're talking about the system by which, if you apply to a university and you write all this information about yourself and an essay and your transcript and your grades and you lay out your extracurriculars and whatever, they factor in all these various aspects of who you are. And if it comes down to an edge case where you're right on the bubble for getting admitted, what are the factors that can get you over the bubble? In both cases, if you read the opinion, it's clear grades are at the top of the list, right? If you don't have a certain level of academic achievement, you're not going to Harvard. But then there are other factors, including legacy admission, if your daddy went there, if your parents went there, race and the implications of systemic racism on education and achievement and what you may have overcome to get to university. all of which factor in. So the case itself, the opinion itself, lays out that grades are still very, very high in the consideration for getting into a school like Harvard. Let me give you a piece of the opinion. This is from Chief Justice John Roberts. We got long excerpts because this is a big case. He writes in part, quote, "The Harvard and UNC admissions programs cannot be reconciled with the guarantees of the Equal Protection Clause. Both programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints. We have never permitted admissions programs to work in that way, and we will not do so today." He goes on to write, quote, "A benefit to a student who overcame racial discrimination, for example, must be tied to that student's courage and determination. Or a benefit to a student whose heritage or culture motivated him or her to assume a leadership role or to attain a particular goal must be tied to that student's unique ability to contribute to the university. In other words, the student must be treated based on his or her experiences as an individual, not on the basis of race. Many universities have for too long done just the opposite. And in doing so, they have concluded, wrongly, that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned, but the color of their skin. Our constitutional history does not tolerate that choice." Unquote. Dean Greene, what do you make of the Chief Justice's logic there?
So one point is, what are the objectives of these programs? And the Bakke decision, Justice Powell's opinion, said that diversity, that was just one opinion, that diversity would be a compelling interest. In this opinion, the court says that the objectives of diversity are too amorphous to provide a basis for limiting the use of race. That's the argument that is being made, that these subject students to stereotypes, and he would say that all students are subjected to stereotypes, and there's no end point. It is overstating what role race might play in the decisions of these two institutions. These are very selective institutions where, in order for anyone to become a part or even considered for that small number of people who are admitted, they have to have an extraordinary record. And that's the argument that both Harvard and North Carolina made. So it's hyperbole to suggest that race is determining the outcome of a decision on admission, even for minorities. We have two district courts, two courts of appeal. The decisions in the lower court opinions ran to hundreds of pages detailing the very, very limited way in which race was used in both cases. And when you combine that with the selectivity of the institutions, I think that there is a great deal of hyperbole in the majority opinion. Now sorry, go ahead.
Oh, I was just going to get to a piece of the dissent, which I think speaks to what you're getting at now. Justice Sonia Sotomayor wrote the dissent, and here's part of what she wrote. Quote, "By ending race-conscious college admissions, this court closes the door of opportunity that the court's precedents helped open to young students of every race. It creates a leadership pipeline that is less diverse than our increasingly diverse society, reserving positions of influence, affluence, and prestige in America for a predominantly white pool of college graduates. At its core, today's decision exacerbates segregation and diminishes the inclusivity of our nation's institutions in service of superficial neutrality that promotes indifference to inequality and ignores the reality of race." She goes on to write, quote, True equality of educational opportunity in racially diverse schools is an essential component of the fabric of our democratic society. It is an interest of the highest order and a foundational requirement for the promotion of equal protection under the law. Brown, meaning Brown versus the Board of Education in 1954, Brown recognized that passive race neutrality was inadequate to achieve the constitutional guarantee of racial equality in a nation where the effects of segregation persist. In a society where race continues to matter, there is no constitutional requirement that institutions attempting to remedy their legacies of racial exclusion must operate with a blindfold. Unquote. That's from the dissent by Justice Sonia Sotomayor. Go ahead, Dean.
I would return to the point I made about the number of applicants and about the small number who had the opportunity to attend Harvard and to attend UNC. And we are talking about how we allocate one of the most precious resources in our society, the opportunity to have a higher education beyond K-12, something more and more important to success. And as Justice Sotomayor points out, this is not simply the admission to ordinary educational institutions. The path to power and leadership in our society lies for many people based upon their opportunity to have an education at one of these institutions that eventually forms the pipeline to important positions of leadership in the country. The Supreme Court is talking about this case as if the idea of merit is already determined by a resort to numerical achievements, test scores, grades. But at these institutions, as the case records in both of these cases demonstrate, there are many, many factors that play a role in one's ability to apply and also to obtain acceptance. So what Justice Sotomayor is saying is very similar to what Justice O'Connor said in 2003 in the Grutter case. She said, we're talking about access to leadership and power through some of the most important institutions that actually form or prepare a class of people who will have even greater opportunities. It's not only that they are prepared for leadership, it's also that by virtue of their attendance at one of these institutions, they will be preferred for leadership. And so Sotomayor, going back, the promise of Brown has not been achieved. It's very interesting in the cases that all of the justices rely upon Brown versus Board of Education for their point of view. But race does continue to matter. And if we think about these cases as cases involving the allocation of the precious resource of a higher education, we can think differently about, I think, the merits of the majority opinion.
Well, let me ask you about what this means practically, particularly if I could ask you to just put on your university educator hat for a second. I should note that a lot of schools came out with statements soon after this ruling, basically saying that they would evaluate it. Michigan State did much the same thing. There's a statement from MSU's Vice President Emily Gherkin-Garant, who said, in part, quote, MSU values diversity and inclusion. All Spartans benefit from a more diverse student body, faculty, and staff, which better prepares our students for postgraduate success and make a more inclusive and welcoming society, unquote. But the university said it's still reviewing the ruling. I got a question from Sarah in California, who emailed, since the affirmative action decision, I've read stories that adversity scores are actually a better tool to bring in a wide variety of students. Is this true? How do they compare? Are there schools using it? What does it show so far? Are there other ways to even the playing field in high school, such as tutors and SAT study grants? for those with lower incomes. Dean Greene, I wonder how you as an educator look at the other options that universities have, considering that there's all kinds of work going on to build a diversity pipeline. It just kind of makes me wonder how much of an impact this ruling will have compared to all the other ways that there are to help disadvantaged students thrive.
I want to address this by making 2 points. One point is that prior to the opinion, the law school deans of the Big Ten came together to say that no matter what the outcome of this case, we are committed to ensuring that there is diversity in our law schools and also in the legal profession. There has been very little change in the diversity of the legal profession, both practicing lawyers as well as in the judiciary, and we continue to be committed to that. At Michigan State, after the court decided the Grutter case in 2003, Michigan State, which upheld the constitutionality of a limited use of race in law school and undergraduate admissions, the state of Michigan adopted a constitutional amendment that forbade any use of race or gender in university admissions, and thereafter the Supreme Court held that that law was constitutional. So since 2008, state universities in Michigan have been unable to use race as a factor in university admissions. So at Michigan State, we at the law school and also the university, we continue to be committed to ensuring that our universities are diverse. We have a diversity, equity, and inclusion strategic plan that states that objective. And one of the reasons I wanted to be dean at Michigan State is I wanted, despite that constitutional amendment, to work to ensure that the legal profession is as diverse as possible. Access to legal services is not only important, we look at the Supreme Court motto, equal justice under law. So a fundamental tenet of the rule of law as a concept is that all people have access to the legal profession and also to the services that the legal profession provides. So what we are doing at Michigan State University College of Law is expanding our outreach across the board, making contact with students at an earlier and earlier time. We're talking with students in elementary schools. We are partnering with high schools, and we're broadening our outreach to a range of undergraduate institutions so that we can be sure that we make, it's not only that that pipeline is as wide as possible, but I also like to think about how we need to light the way to the legal profession by making access to the profession more visible.
Can I tell you something that ashamed me? As soon as I thought it, when I was looking for people to talk to about Supreme Court cases, I thought about a variety of institutions, and I sent an email to the University of Michigan because I know some people over there. And they said, no one here is available. You might try Michigan State. They have some wonderful speakers. And contacted Michigan State and they said, the dean is willing to speak to you. And I thought, okay. Can I tell you how embarrassed I was as a black man that I never considered that the dean of Michigan State's College of Law could be a black woman? Can I just tell you, when I saw your picture, I was like, damn, I thought I was better than this. Never occurred to me. I mean, but do you know what I'm saying? It's even now, just having not grown up with that idea of, it's the whole thing with Ketanji Brown Jackson. Right, on the Supreme Court, the idea that you can't even visualize it. It's not like you thought it was impossible. It's just the possibility never occurs to you unless you see someone in that position and then go, oh, that's normal. That can happen.
And that is a part. You could say its role models are important part. But I should say, by the way, that there are more than 36 Black female deans now of law schools in the United States. But that's a very recent phenomenon, and that is all post George Floyd, as so many other things that have changed or started to change in America. But we're committed to complying with our Michigan Constitution and also making sure that the benefits of a legal education are available to students from all backgrounds. We do that by making it clear that we want to have a diverse student body. We have implemented an inclusive approach to our outreach and our admissions. We have sought much more information about our applicants to determine their preparation for law school. And we also fundamentally believe that diverse teams will do better work in our society because they bring not only their differences in experiences, but as Scott Page says, their different cognitive styles that come from their experiences to the problem-solving opportunity. And of course, that's what lawyers do, is solve problems. I would also say part of the reason that the Big Ten deans decided to make a statement ahead of the decision is to call attention to the continuation of the segregation in the legal profession. Several decades ago, we had explicit segregation in the legal profession. But we should remember that it was not until the 1970s that law students of various backgrounds actually were able to attend law school. Law schools opened up. And the programs, of course, that some of these cases challenge, some of those programs date from that time. If we look at the history of admissions to legal education institutions, most of those institutions had a handful of minority graduates up until 1971, that we did not really begin to meaningfully integrate the legal profession until the 1970s. And so it's not really surprising that whites are still overrepresented in the legal profession. That's changing. But at the same time, let's look at lawyers of color. They are expanding, but still very much underrepresented. And I do want to say for Black lawyers, the number of lawyers is virtually unchanged in 10 years. In 2012, Black lawyers were 4.7% of the profession, and they are 4.5% in 2022. And that's far less than the percentage of Black people in the U.S. population, which is 13.4%.
Let me squeeze in one more break, and then I got a few more questions for Linda Sheryl Greene, the Dean of the Michigan State University College of Law. I'll get to a few more of your general questions. There's also plenty of questions about the trustworthiness of the court and the influence of outside individuals on Supreme Court justices. We will get to that when the Nightlight continues. If you're enjoying the Nightlight so far, consider showing your support by becoming a paid subscriber. You know, this is meant to be more than just a show. It's meant to be a community for people like you, people who want to be part of building a better world for everyone, people who put connection above politics. Mainstream media is not doing it, and social media seems incapable, so we've got to build it ourselves. I've spent 20 years doing this work, and now I'm free to do it in new ways with no one to answer to but you. So, come be my boss. Some of the benefits of becoming a paid subscriber include access to all of my posts on Substack and the ability to leave comments. You get all the podcasts and videos ad-free and early. You can engage by text, audio, or video, including on YouTube live streams. There'll be a monthly Q&A episode where you can ask me anything, and you'll get bonus episodes and content throughout the year. Also, consider subscribing at a higher level as a founding member. In addition to those other paid benefits, you get a complimentary gift and a quarterly check-in live with me. To subscribe, go to nightlightshow.com. You can also get limited access as a free subscriber. Whatever you choose to do, sign up now at nightlightshow.com. Thanks. Back now to our conversation with Linda Sheryl Greene, the Dean of the Michigan State University College of Law and also MSU Foundation Professor at the College of Law. Let me get to a few real quick questions before I got to let you go. There's a lot of malaise among some of my listeners over kind of the state of the world, and that's okay. But this is a good place to air that. But Diane wrote on Facebook, when Supreme Court justices are writing dissents saying that majority decisions are blatantly unconstitutional, how do we avoid giving in to utter despair? To think about how very, very long it's going to take to get these super partisan judges off the court, I'm just feeling such deep, deep despair. Diane, thank you for sharing not only your question, but also just for being honest about what you're feeling. I know that's hard to talk about because it kind of can feel futile to even say it out loud, but thank you for expressing that. Dean Greene, I wonder what gives you hope for the future of the judiciary? What gives you hope, if anything, for the future of the rule of law?
Well, I'm super hopeful about the young people who want to become lawyers, and they want to do so many different things, but they are so enthusiastic about this opportunity. But I think that we all have to play a role in making sure that the Supreme Court is a Supreme Court that we want to be proud of. And that probably means that for your younger listeners who will be around a lot longer than the two of us, they have to be much more focused on not only the United States Supreme Court and the people who become justices of that court, but also on the people who are judges all over the country in state courts, in lower federal courts, as well as in the Supreme Court. I think that looking at it now, there may be opinions with which you disagree and that make you feel hopeless. But you have to remember that I became a lawyer over 40 years ago, and things were very different in the world when I became a lawyer. But I joined the legal profession because I was passionate about opportunity for all people. And there's so much work to be done. I tell my new students, our generation left to your generation an amazing number of problems to solve. We've done our best, but we aren't there yet. And we look at the statistics about the disparities in educational achievement, and we can go across the board in our society and see those kinds of outcomes. For me, that means that there's so much amazing work to be done as we continue to reconstruct our society in a manner consistent with the motto on the Supreme Court, equal justice under law. There's a lot of work to be done, and all talented people are welcome to join that effort.
Nanette wrote on Facebook, "We need term limits." And Barbara wrote on Facebook, "I still don't quite understand how lifetime appointments should even be a thing." I know this question comes up, it seems like every 45 minutes when we talk about the Supreme Court. Why are they there for their whole life? 9 people, and it's like were they anointed by Jesus? Like, it's always the question that comes up. Why you have people on the Supreme Court that just are there forever. I see the benefit, like I see the argument of having people with long, deep knowledge of the law and who are insulated from political machinations. I also see the argument for having people who get a little fusty, a little stale, and you need people who kind of understand the world as it is now. I don't know what the right answer is. How do you see the whole term limits debate?
Well, term limits are a feature of many state judicial systems, or various combinations of an appointment. The governor appoints a person, then stands for election, and then has to run again. So we have a number of systems in the United States. In our federal courts, we have life tenure primarily to insulate judges from influence that might affect their decision making. And that, of course, whether you feel excited about that may depend on which justice you love. And I completely understand that. But life is long, and eventually there will be new justices on the Supreme Court. What I think is really important for people who care about the decisions of the Supreme Court to be sure that they are involved now and in the future in the identification of people who ought to serve on the Supreme Court, as well as in advocacy for or against people they believe who would be harmful to the nation. But we know that there are going to be many points of view about that. But I think that overall, I think life tenure, there are other arguments that are being made. Why don't we expand the Supreme Court so that it's not limited to 9 people and 8 people who graduated from Harvard? I don't have anything against Harvard. I taught at Harvard. But maybe we need a few more justices who have been exposed to more of the great minds involved in legal education than just 2 institutions. I think that's appropriate. And it may be that the workload, and this, of course, could be another important program, it may be that the workload of the Supreme Court requires that we have more justices. There, I think, is a commission underway now to study that. I think it's really important for the question to arise in a manner that is not pitting a particular court against a reform movement, but is focused more on what are the needs of the people that might be served by an expanded Supreme Court. The opportunity to remove Supreme Court justice is very limited, or even a lower court judge is very limited. And I think that should be the case. We prize independence in the federal judicial system. And the life tenure rule reflects that prioritization of judicial independence.
Love to hear from some of you listening what you think about the future of the court in terms of the size of the court, more justices, fewer justices, lifetime tenure. Feel free to share your thoughts on that. Joshua at nightlightshow.com. I'm sure that debate is going to keep going, and so I might as well bank some of your thoughts now because we're going to discuss it again, I am certain. But feel free to let me know what your thoughts are about that. Let me also ask you, Dean, in the time we have left, about the concerns over the trustworthiness of the Supreme Court. There's been a lot said lately about the economic relationships that some justices have with the rest of the country. This week, the AP dropped an investigation about how universities have invited justices to speak or teach. Michigan State bought more than $100,000 of Justice Sonia Sotomayor's book, My Beloved World, and gave them out to incoming freshmen back in 2018. It was part of a local reading program. They announced the program in March. Justice Sotomayor came and spoke that August. And to be clear, for y'all listening, this is before Dean Greene was at Michigan State University. Now, I totally see the value of meeting Supreme Court justices. I got to interview Justice Stephen Breyer a few years ago, and it was an amazing experience. I interviewed him at the Aspen Institute. We kind of went head to head. I pushed him on a question. You know, he got feisty with me. It was fun. It was worthwhile. And I'm so grateful I got to do it. And also, to be fair, the AP report says that Justice Sotomayor has been pretty strict about avoiding events where donors could be nearby, like university donors. With all that said, even the appearance of influence, even the appearance of impropriety, of paying for access, it's a bad look. It's just a bad look, especially right now with everything being so hyper partisan and people being quite cynical about the trustworthiness of the court. How should we think through this?
Gosh, we know that the appearance of integrity and impartiality is very, very important, as is actual integrity and impartiality. We also, your listeners, they sound very sophisticated. They probably already know that the federal judges in the country are subject to very strict conflict of interest and disclosure policies. And of course, now as a result of all the recent publicity, we know that the Supreme Court is left to judge itself. We know that these are important issues and that Congress, the United States Senate, will want to have hearings on those issues. We have at stake the independence of the judiciary, and that will always be a factor in any conversation about this. We know that integrity and the appearance of integrity and the appearance of impartiality is very, very important. At the same time, so far, we have left to the justices their decision to recuse, is what we call it, their decision to recuse. We have left that to individual justices.
I sometimes wonder how much of an impact that coverage will have. I mean, ProPublica just did that investigation about Justice Clarence Thomas and his connection to Harlan Crow, who's a real estate magnate. Then there was Justice Samuel Alito and Paul Singer, who's a hedge fund billionaire. Justice Alito never disclosed these trips he was taking fishing with Paul Singer, and Paul Singer's companies had cases before the court. Alito did not recuse himself, and he did not declare the expenses, which could be illegal. And not only was he not contrite about any of this, he put an op-ed in the Wall Street Journal preemptively before the ProPublica investigation came out. Now, to me as a journalist, that feels like an attempt at a chilling effect. That feels like trying to intimidate ProPublica out of publishing their piece, which is not cool under the First Amendment. So I'm not sure how to rein the court in. I mean, Chief Justice Roberts doesn't want to do it. Senator Dick Durbin tried to get him to testify before the Senate Judiciary Committee. And in April, Chief Justice Roberts wrote him a nice long letter saying, no, we've got our own rules, but thanks for asking. And went back, Chief Justices haven't testified since 17, whatever it was. Like he went deep into history books to say, no, I ain't talking to you about this. So as an average American, I don't know who's going to make them do it. They're not doing it themselves. Like, are we just kind of stuck with this?
If there is a specific situation in which a Supreme Court justice is favoring a person who has provided a material benefit, I feel confident that if there is a specific situation, I feel confident that most justices would recuse. And remember, they don't have to say why they decide not to participate in a case. And so that is why I do believe that the more education, the more public pressure, the more press investigation of these circumstances may give rise to constraints. The constraints may not fully affect those justices who are engaged in the behavior or maybe have come to believe that this behavior is neutral. But I do believe that these stories and this information will affect future justices and other justices. And I also think that the Senate now has an opportunity to provide a better record during confirmation hearings of potential relationships and conflicts of interest, and maybe during the confirmation process might be able to ferret out some of this activity or express its expectations about how a justice will manage relationships that might cast doubt on the integrity of the court. Again, I am very much an optimist that even though some of these stories seem to be beyond the pale of propriety. I'm an optimist that there are mechanisms, I think, that we will see that will be able to check these practices, and that maybe at the end of the day, the one or two justices that we hear about will become outliers. Eventually, they will leave the court, and in combination with the confirmation process and maybe a new consensus on the Supreme Court, other justices may be or feel that they should be much more modest about their association. So I'm very optimistic.
Linda Sheryl Greene is the Dean and MSU Foundation Professor of the Michigan State University College of Law. Dean Greene, you've been very helpful walking us through all of these cases, answering our questions. It has been a pleasure. Thank you very much.
Great. Thank you.